subsection 1, with regard to similar products, the rate should be identical. A small difference is allowed. It can be sometimes, it can be very difficult sometimes to decide whether products are similar. For example, is wine similar to beer? Okay, so in true case law, you have to first identify in your question, is it similar products? Is it competing products? So sometimes it's actually very difficult to identify whether products are similar or whether they are competing, right? So Commission versus UK Wine and Beer said that wine and beer were not similar. Why? Because different raw materials were used for production, and the products also had different characteristics. Though they both had alcohol content, it was considered that they are not similar. So wine and beer are not similar products. Okay. Commission versus, now first we're identifying similar products or competing products. Okay, so first, that's our first task. Commission versus France, light tobacco was held to be similar to dark tobacco. France was required to equalize the tax because they were made from the same. Why was it similar? Same basic raw material was used, same properties, and it fulfilled the same customer need. Okay, so light tobacco was supposed to be is supposed to be similar to dark tobacco. Then we have Commission versus Denmark and the case of John Burca and Sons Limited. Court accepted that wines made from grapes and wines made from fruits were similar, although they had different alcohol content and it was achieved differently. Both basically were similar. Both came from the basic. So why? Because both came from the basic product and both were fermented. Although so, Scotch whiskey and liqueur made from fruit were not similar. So Scotch whiskey and liqueur made from fruits are not similar. They are not from the basic product, and one is made from cereal and the other one is made from fruit. So there are different sort of factors that you look into when identifying whether the products are similar or different. Understood? Do you understand these cases, how you identify similar products and different products? Usually the characteristics, raw materials, method of production, machinery, etc. If you're using the same thing, then it's a similar product. Okay, that's how you identify similar products. Are we good? Raise your hands if you understand for me to move on. Okay, thanks. Okay, Kavala. Registration of second-hand vehicles were being of fiscal nature. Domestic products were calculated differently. Courts defined similar products with similar characteristics. So it was with regard to second-hand products. Okay, so second-hand products, domestic products were calculated differently. Foreign products were calculated differently. Court defined that there are similar products and similar products in terms of second-hand vehicles, and because they have similar characteristics. Commission versus France, spirits based on grain, which is whiskey, rum, gin, and vodka, are similar to spirits based on wine and fruit, Cognac, Calvados, Armagnac. If you can't, in the case went on to say, with similar products, if you can't sort of identify direct discrimination, then you can identify indirect discrimination. It could be met. Okay, you can't, in that case it says that, okay, no, we have to have a tax because of practical difficulties. You can't have practical difficulties as an excuse or a justification into having two different taxes for similar products. So practical difficulties cannot be justified for the application on internal taxation. So for internal taxation, you can't say because of practical reasons we're having two different tax. That is not a good enough reason. Okay. Article 110(2), that is on other products. With regard to competing products, the rates need not be identical, but the member states should ensure that there should be no protective effect for the competing product. Example, gummy bear, chocolate example. The test for ECJ users to decide whether products are competing is whether customers regard those products as fulfilling the same consumer needs. So you identified that in terms of the specific reason of these gummy bears chocolates, because which are normally sweets are directed mostly to children. Those are the consumer needs. So do they have similar consumer needs based on the type of products? At the time of the wine and beer case, Commission versus UK Wine and Beer, tax on wine was higher than on beer. So the wine and beer case, the tax for wine was higher than beer. Despite this, the court felt that consumers' attitude are not frozen in time. Due to the greater availability of imported products resulting from free movement of goods in the EU, customers could try new things and should not be deterred from doing so by high taxes. So light wines at the cheaper end of the market were held to be competing with beer. So in terms of wine and beer case, yes, there is a difference. They are two different, they're not similar products, they're different, okay? So because of that, they held that in terms of cheaper wines and beer, they are not two different products completely, but they are in fact competing with each other. They're other products, they're different products, but they can compete with each other, and you have to identify whether there's, so if it falls under competing products, you could identify if there is discriminatory taxation or not. If it's completely unrelated products, you can't have discriminatory taxation. Why? Because there's no similar products and there's no competing products to identify in terms of to identify if there is in fact discriminatory taxation. So in this, because they said, okay, we need to give a wide, like the consumers are allowed to have a selection of goods. So cheaper wines, okay, are they were held to be competing with beer, and then you go on to identify if there is indirect discrimination or direct discrimination. Would the consumers sort of switch between light wines and cheaper wines and beer if the price of wines go up? Would people switch to beer? If so, they will say it is discrimination under Article 101, subsection 2. Are we good with that? Any questions? Okay. Article 110 also applies to exports, although not mentioned in the article, to ensure that there is no deterrence to free movement of goods. So Article 110 is also for exports. So let's say my country is making tea. Okay, so Sri Lanka is making tea. And if it says for domestic products, you can sell tea, but, no tax. But if you're exporting tea, you have to pay a higher tax. Is it discrimination based on free movement of goods? Yes, because you won't be exporting tea to others. Why? Because there'll be a reduction of exporting tea to others because you have to comply with this expensive tax. Okay. So example, in the case of NIGAD, levy on pigs slaughtered for domestic market or live export was more advantageous for sale on the domestic market. The levy was a breach of this article. So even though the article does not recognize it, case law has recognized even for exports, you can apply discriminatory taxation. So for example, let's say my country is, again, I'll repeat my example, is making tea, but to sell the tea for the domestic market, there's no or very less tax that is involved, but to sell the tea, to export the tea, to send it to other countries, there's a higher tax, which means that indirectly I'll say, okay, I'm not going to pay for it. I rather profit from selling it to the domestic market. I don't want to pay a huge tax to send it abroad. This will hinder free movement of goods because goods won't be in free circulation, and I won't be free to sell it abroad because of this. So the court held that in terms of certain exports, it could fall under discriminatory taxation. Do we understand that? Raise your hands if you're okay with that. Thank you. Now, if you have any questions, please put it on the chat box. Next, we try to identify if there's direct discrimination or indirect discrimination. Now, what is direct discrimination? If different tax rates apply depending on the origin of the goods or whether they are home produced or imported, this is called direct discrimination. So what is direct discrimination? Direct discrimination is when you make have a charge made for a certain product, a tax for a product based on it coming from a different country, or based on the fact, home products will not have a charge or will have a less charge. All imported products will have a charge. That is called direct discrimination. You're directly discriminating imported products. Okay. and that is direct discrimination on the basis of origin and clearly breaches Article 110. So it's a clear breach. There are no exceptions for direct discrimination. Ha Petroleum, national rules, so the national rules required Danish ports to import a 40% surcharge on the basic charge paid for goods uploaded from ships. The tax was imposed only on goods loaded on ships arriving outside Denmark. Okay, and thus constituted direct. So there was a surcharge, a 40% surcharge paid for goods that are being unloaded, right? In Denmark. And the rule in Denmark was only applicable for goods that are coming from other countries to Denmark. That is complete, easily identifiable direct discrimination. You can't do that, okay? Because it's direct discrimination based on origin, right? Even though it doesn't say the origin, Italian people only will have you don't have to say that. If you say all imports have to have this surcharge, then it amounts to direct discrimination based on origin, because their imports, they come from other countries. Then we have Latic versus Saloy. Powdered milk from Luxembourg was imported into Germany, but was subject to tax, which did not apply to domestically produced products. So what happened here? Powdered milk from Luxembourg, which was imported into Germany, but was subject to a tax which did not apply to domestic products, domestically made milk products. So that amount to direct discrimination as well. Okay, so direct discrimination is quite easy to sort of identify. Indirect discrimination is where the tax appears to be neutral and makes no reference to the origin of the product, but on the basis on which the tax is levied is on a feature which in practice only occurs in imported products. This results in indirect tax protection for domestic products. So again, if you go to the example of chocolate and gummy bears, you don't say imported products will have a tax for chocolate. No, you don't say imported products have a tax for chocolate. You just have a certain feature and you increase the tax. So it doesn't say which origin you come from or the reason that it comes from a different country or a particular country has to have a charge. No, there is a tax levied for a feature of the product. And if it kind of affects the goods from coming into a country, and because of another, and if it shows that your domestic products are protected, it amounts to indirect taxation. Okay, it amounts to indirect taxation, which amounts to indirect discrimination. In cases of indirect discrimination, it is necessary to prove that there is a protective effect. So in terms of indirect discrimination, you have to prove that you're trying to protect a domestic product. Okay. The popular case for this is Bobby. Can you read this case and explain it to me, please? I'll give you 2 minutes to do that. Okay, who wants to explain Bobby? Dinesha, do you want to give it a go?
Okay, Miss. Bobby versus Haftor Solomon. In this case, basically discussed about the taxation of beer in Germany. basically the law imposed to charge low rate of taxes for small producers, and therefore Bobby got benefit from that one. And basically the large quantity of beer producers out of the country, the government imposed high charges of taxation. Therefore, there is a discriminatory effect to the producers, and as a whole, the Belgium small producer group got benefit from that taxation method when compared to the large scale one.
Okay, very good. Okay, let me explain again to the others. This Bobby versus I can't pronounce that the second term. This was on the German system of taxation of beer. So they were taxing beer. Okay, the system benefited small producers, which seems very good, right? Like it seems very noble, excellent, because small producers were having a very low charge. Okay, because they have lower volumes. Okay, so small beer companies, small beer producers were this is for importers, exporters, any from wherever within the EU, they were imposing lower taxes on small beer producers. Lower taxes. Now, does it sound fair? What do you think? Mudit, Piumi, what do you think? Does it sound fair? Do you think it's fair to have?
Could you repeat the question?
Right. So what happens here in this is there was Germany, they had a lower tax. Okay, so lower tax on volumes on small producers of beer in Germany. Okay, so in Germany, small companies, small beer producers will have lower taxes. Do you think it's fair? Big companies will have higher taxes, small companies will have lower taxes. Do you think it's fair for small companies? Do you think it's a fair rule?
Smaller companies having a small amount to pay would be fair.
Yeah, it will be fair, right? Because you're trying to, sort of enhance small producers to, make to still stay in business. So bigger companies which have higher volumes, like let's say Heineken, I don't know, so in terms of like big companies like such as Heineken and all of that, because they mass produce, they'll have to have larger, their taxes will be higher, whereas small, like home, like, maybe, naturally sweet beers or things like that, small producers, okay, will have to have a lower, they will have to pay lower taxes, right? Because this is to enhance or enforce and sort of allow smaller companies also to sustain in the market. Okay, so lower taxes for small producers, higher taxes for bigger producers. Okay, but for imported products, so let's say it is 50 rupees a bottle. Now this is, I'm going to use Sri Lankan terms. So let's say a bottle of beer or whatever for small producers is 50 rupees. For large companies, for the same amount volume of beer, it is 100 rupees. Okay, so 50 rupees for small producers. Big producers, people who make beer in higher volumes will have to pay 100 rupees per bottle. Is that fair? Like you said, Piumi, what do you think? Again, I'm asking you again. Your answer is right. You think it's fair?
I would say it is fair.
It is fair because you're trying to sort of make these small beer producers sustain. Now, for imported products, so products that are coming from other countries, you have a mid-weight tax. Mid-weight tax between 50 rupees and 100 rupees for other people from other countries who sell beer into Germany. Okay, so that's about, let's assume 75 rupees. Okay, so all other beer producers who come from another country will have to pay 75 rupees for a bottle. Do you think that's fair?
Based on the principles of non-discrimination, it is not fair.
Why? But do you think, like, Germany is being fair? It is a lower tax for imports, but do you think Germany is being fair? I mean, do you think importers will benefit from this? Do you think importers will benefit from this, Pumi? They only have to pay 75 bucks.
But then again, ma'am, if it's a small business, like in the case of Bobby, it's not fair.
Excellent. It looks fair because importers have to pay 75 rupees a bottle. But the problem which arose here was, what about small beer producers from other countries, like Bobby? Okay, now Bobby is in German, like Bobby, that's what happens. So let's say small beer companies in Germany, they pay 50 bucks, but the same size, the same sort of company that is an importer from another country, paying 75 bucks for a bottle is, of course, it's discriminatory on that, right? Because if that beer comes into Germany over 50 rupees and over 75 rupees, who would you sort of, I mean, what would you sort of go with? You would go with the domestic product, which shows that Germany is actually having a protective effect on their German products. Do you understand that? Yeah?
Yeah, clear, ma'am.
Okay. So for imported products, it was different, where they had to pay a price midway between the two rates imposed on German beer producers, and it was a uniform rate for every big producer, small producers, everybody. This affected Bobby, which was a small Belgian brewery, which would have to pay less if it was a German brewery. So if Bobby was in Germany, they will have to pay a less tax. Okay. And the court ruled that this was indirect discrimination. Okay, because they levied on a sort of feature of the product. Okay, I hope you guys understand. Danske, the case of Danske, which concerned a very high registration tax on new cars sold in Denmark, which were all imported. In this case, there was no breach of Article 110 because there were no Danish products to be protected. So this was about new cars, which had a high taxing, which came from abroad. But when it came to discriminatory taxation, the court held there is no discriminatory taxation because Denmark wasn't producing these cars. Okay, there was no Danish products to be protected. Understood? Okay, then finally we come to justification. For direct discrimination, it can never be justified because you can't justify on direct discrimination. But for indirect discrimination, this could be objectively justified in the case of pharmaceutici. Okay, so indirect discrimination, there is objective justification. Okay, so and then you can get away with it. There are, however, some cases where indirect discrimination has been justified in chemical pharmaceutici and Commission versus France. So these are the two cases. Okay, Commission versus France. Although tax favored domestic product, it may not be a breach of Article 110, as naturally sweet wines from other member states could also have benefited from the lower tax rate. So this was based on naturally sweet wines being taxed lower in France, and the court held that yes, sweet wines are much lower, the taxes are much lower, but sweet wines are very small product and not everybody sort of consumes it. So though there is a different tax which protects sweet wines, it's okay because other member states also could benefit from this lower tax on naturally sweet wines. So indirect discrimination, there could be objective justification. If there's an objective justification, it falls outside Article 110, which means it's legal. Okay. Consequences. Now, what happens when it comes to a breach of Article 110? It depends on what breach you make, whether it's an Article 110(1) breach or Article 110(2) breach. For similar products under Article 110, if there is a breach, if you find out a breach, there's no justification, and if you find out there is a Article 110 breach, what happens? For similar products, strict equivalence is the consequence. You have to equalize your tax. Okay. In the tax applied, or if there's sliding scale, what the imports are placed, you have to put it to the lowest point of the scale, right? So what happens? What do you mean? What it means to say strict equivalence is you have to try and equalize your tax. If for some technical reason you can't equalize your tax, you have to bring it to the lowest point possible. That is called strict equivalence. So for similar products, you have to have strict equivalence. If not, you have to bring it to the lowest point of the scale. For competing products, it's not necessary that the rates need be identical. You can have different rates. Rather, the member state must ensure that the rates are such that there is no protective effect for the competing product. So you have to lower your tax, but you still can have a different amount. That's okay, as long as you don't have a protective effect of your, as long as you have to make sure that the domestic product does not have a protective effect. If it doesn't have a protective effect, you can have a different tax. For example, my gummy bears example, you can have a packet of gummy bears for 50 rupees and a chocolate for 80 rupees. It's fine, because as long as you can prove that you're not trying to protect your domestic product. Okay. And what happens to third country goods? Article 110 also applies to goods in free circulation. Okay. However, generally Article 110 does not apply to third country goods directly imported into member states. So once goods come into your country, it has to have free circulation. Then Article 110 applies. But if you're talking about third country, India to Italy and India to Spain, if there are different taxes there, Article 110 will not generally apply. Okay, if it's a third country directly applying to these different countries and different taxes are applied, Article 110 may not be possible. Even where provisions of non-discriminatory taxation have been included in the relevant free trade or association agreement, the court has given a more limited interpretation to them. Generally, where goods are imported from a third country with which the EU has no such agreement, Article 110 does not apply. Where? Because you don't have an international agreement between that and the third country to have a similar tax for all. Because of that, when goods come from third countries, and let's say a mug from India comes to Spain, the tax is 30 rupees. From India to the same mug from India to Italy, 40 rupees, you can't help it, because if there's no agreement, a EU agreement between India and EU, then you can't sort of have Article 110 discriminatory taxation. Okay, understood? I do not have, I'll get back to you with regard to the textbook. When I do get my hands on it, definitely I will upload all soft copies. Any questions? Any other questions? So this is the next topic that we will be doing, which is part 2. So we'll be talking about Article 34, 35, 36. Okay. I didn't want to anyway, I have no time, but I didn't want to start it today because it's a whole new, you need to have one entire class without a stop start. Any questions? Okay. All right. Okay, good luck for all your mock exams. I will see you, I'm assuming next month. Merry Christmas and have a happy New Year as well. Hopefully we won't go into another lockdown. All right. Bye, guys. Any questions, you can message me directly, okay? Or email me. You have my email address.
Thank you, Miss.
Thank you, ma'am. Happy holidays.
Happy holidays. Okay.